attachments will be considered at the discretion of the commission, but not necessarily.
I believe we start running into a risk of losing that objective merit scoring criteria, where each of you are able to objectively describe and reasonably justify your rating. The information provided between the summary and the attachments should be considered to the extent that you're able to reasonably explain your scoring on any of those components. It should be in the whole context of that application submission.
So with those changes, I guess I would still move that we accept those changes.
So,
Are we doing
All in
that?
favor?
I
Aye. Thank you. Did you have anything else?
at this stage, the only other point of immediate discussion goes back to those same scoring descriptions and how those points are to be allocated in schedules 1, 2, 3, and 4. This is the final rubber meeting the road part where we started getting to last week, and when we decided we wanted to have someone like Director Armstrong come in and allow us to also provide greater context for that idea. If a methodology similar to what Director Armstrong is going to be used, which is frankly more objective and easier for you and defensible, the only thing left to do is ensure that the appropriate weights in schedules 1, 2, 3, and 4 are there for us to assign those individual rating components. The good news is we have bullet points under them. They're already broken down to some extent.
So, for example, if we go to the cultivation facility, section E, schedule 1, qualifications of applicants. And we have, when we discussed at our meeting last week, we weighted the qualification of the applicant at 10%. And the question we had, do we have to break down each item that's bulleted here to distribute that 10% point-wise?
And it appears that several of these may be able to be combined. Because we have an overall percentage breakdown, if we start by looking at, I think, Schedule 2 is the best because it's the longest. That may give us the number to work off of. If we observe, if we see how those points are broken down in what all of you agreed was the most important of the 4 schedules, the rest of them can fall into place around that.
Well, we were supposed to get some information, like this is a scoring description here, and we did we get the information or regarding how to break this down? Did we do okay in breaking it down based on the percentages? Because we stopped when we all stated we did not go over what we felt was important.
As I was saying, the bulleted points under Schedule 2, where you start seeing 2A where it talks about the plan for producing sufficient quantities of approved medical marijuana, that could be one scored component. The second could be the description of the procedures to be used, which include the grow mediums and pesticides. We have a high-level breakdown already based on the amendment, your rules, and the existing applications that we referenced when kind of putting these together. And what we need to confirm is if it's broken down correctly, to just make the final structure around that concept.
Why can't we, I'm just a question, why can't we do the whole section just 50 points and not do any sub-points?
That goes to the danger that Director Armstrong mentioned. If you choose to do that, you can, but I would counsel against it because that wide of a range and this many different components could create the perception that there's not a standard objective evaluation for the merits. And in moving to a merit-based system, that consistency and that set of standards is what is likely envisioned by the people who were discussing.
I guess my concern on that is, you got 5 people here, and just like we did at the end of the last, kind of towards the end of the last meeting, we all kind of said, well, how many points would you put on section A? And we all had varying answers on what we thought was important. And it is a merit system to some extent. The broader range of points and the less we constrain ourselves, I mean, it makes it where you have to get basically the approval of all 5 of us. Because if someone, if you were really weak on, I mean, for me, if you're really weak on public safety, patient safety, drug diversion, then I don't care how good your pesticide control is. I really don't care how good your transportation is. What I really care about is the welfare of the public and the way these medications can affect our state. And that's the same thing with the opiate crisis, et cetera. And this country had been turned upside down by opiates because it was done. They were good on marketing, they had great packaging, they knew how to ship it. But what we didn't know how to do was educate people on the proper way to take an opiate. And now we have a disaster. So that should have been a much heavier emphasis, and that's what I would emphasize. And I don't want to be hamstrung by that because, and that someone else may say, well, I don't think that's important. I think what's important is that the transportation or that the pesticide is used or that it's waste. So I think that to constrain us on a narrow point score actually weakens when we get up to the top 5. I think it's better that they pass the muster with all 5. So yeah, if you fail at one commissioner and you failed what he thinks is a good application, then you may not make it. It's like
That will